Okay, good evening, Board of Zoning Appeal. This is your training session for March the 27th. This is just an informal training for you all. You're going to be going over some land variances, and what we have before us tonight is a well-versed attorney from the city of Lynchburg, retired. His name's Walter Irwin. Walter received his law degree from T.C. Williams Law School and practiced law for 45 years. He joined the Lynchburg City Attorney's Office in 1980 and became city attorney in 1991. He served as a Lynchburg city attorney until he retired in 2021. During his time as a local government attorney, Walter served as the president of Virginia Local Government Attorneys Association and as the president of the Virginia Council of School Attorneys. In 2007, he received the Local Government Attorneys Edward C. Finnegan Award as someone who has made significant contributions to the practice of local government law. In 2016, he was appointed by the governor to serve on the newly created Virginia Conflict of Interest and Ethics Advisory Council and served a 6-year term. From 2009 to 2011, he served as a faculty member of the Virginia State Bar Professionalism course. Since he's retired, Walter has been teaching a course on state and local government law at Liberty University Law School. And I'd like to present to you Mr. Irwin.
Good evening. Good evening, and thanks for coming to tonight's presentation on the role of the local Board of Zoning Appeals. It's an ego boost to be asked to come and do this type of presentation, and frankly, I could use a bit of an ego boost lately. Let's see. You know, for Christmas, my daughters gave me one of those DNA testing kits where you send off a sample and they send you back your ancestry. And when I got mine back, it said that, 58% of my ancestry was British and Irish, 20% was French and German, 3.5% was Scandinavian, 3% was Spanish and Portuguese, and 1.5% was Native American. And there wasn't any really thing surprising about that. We'd already always suspected that our ancestors probably came from Britain and Ireland. But what was surprising, along with those test results, they sent a little letter saying, oh, by the way, you might be interested in knowing that you have more Neanderthal DNA in your genetic makeup than 90% of the population. So, Neanderthal DNA was a surprise. The Neanderthals were so limited, they're extinct. So my wife's view was, well, she didn't need any fancy lab results to tell her that. She knew she'd been living with her Neanderthal for years. But being told you're chock full of Neanderthal DNA is kind of a bummer. So being invited to do something like this of a public body is kind of like, well, you may be chock full of Neanderthal DNA, but you can still be of some use and help, for the community. So during tonight's presentation, if you have any questions, please feel free to ask them, as we go along, and I'll be glad to try to answer them. Just just a little bit of background. When we talk about zoning, what I mean is zoning is a process that a locality uses to control the land and the buildings and structures located on the land. Zoning ordinance typically divides your locality into districts, residential, business, agricultural, commercial, designates the uses that are permitted within each district, and establishes the development standards in the districts, how tall buildings can be, the density, how many of them there can be, whether or not there has to be landscaping, what the setbacks are. Zoning ordinances vary a great deal from state to state. Some states, like New York, give their local governments much more zoning authority than Virginia does. But Virginia gives its local governments much more zoning authority than South Dakota gives its localities. So there are a lot of differences in zoning. Zoning philosophies change from time to time. In the early 1990s, when zoning really got kicked off, it was believed that the best zoning practice was to establish designated districts and separate the land uses that could go in those districts to prevent incompatible uses from being mixed with one another, like you didn't want commercial uses in with the residential district. In recent years, that philosophy has changed. Local governments have decided, planners have decided that trying to segregate all the uses, that really didn't work out so well. Maybe it's a good idea to have mixed uses. Lynchburg, not too long ago, adopted what's called a traditional neighborhood zoning ordinance that says we're going to allow residential, commercial, business districts all within the same district and set the guidelines. So zoning is very fluid. Zoning is one of the most controversial issues that public officials have to deal with when you're telling people what they can and can't do with their property. Some people believe that property owners believe that zoning unreasonably interferes with their rights of property owners. Other citizens believe zoning doesn't go far enough to protect them. For example, if you're a landowner and you own property along a highway, you might be upset if the local government doesn't allow you to put up billboards or cell towers on your property because you're being denied a source of revenue. Other citizens will believe if there are any cell towers or any billboards along a road, then the government, they're eyesores, and the local government ought to do something more to get rid of them, to control those uses. So zoning tries to strike the balance, and that is a BZA's role. We'll talk about that in a little bit. But you help achieve the proper balance of zoning in your locality. But zoning is controversial. Some of the most heated council meetings I've ever attended have dealt with zoning matters. One of our council members who just went off council, and when he gave his farewell address to the press, he said, with my experience on council, the votes that weighted the most on me have been zoning decisions. These decisions have been hard because you're trying to find the line between growth and things like affordable housing, and it's difficult to balance those concerns. So zoning is something that can stir up emotions. What makes up the zoning process in Virginia? There are three components of zoning in Virginia. The first is a comprehensive plan. That's required. Every locality has to have one. The comprehensive plan is a general guideline for your community, how you think it should develop. We think business districts ought to go, we think business uses ought to go here, we think residences ought to go here, here's where the public infrastructure should be. You have to have a comprehensive plan. It has to be reviewed and updated every 5 years. Then there's your zoning ordinance. Now, in Virginia, your local government is not required to have a zoning ordinance. And there's some rural communities that still don't have zoning. I've got two brothers who live in Floyd County. Floyd County does not have a zoning ordinance. It has a comprehensive plan, but no zoning ordinance. Now, the zoning ordinance is the document that establishes the standards that the locality will follow. What types of zoning districts are you going to have? Residential, business, agricultural, and the development standards for each district, and the administrative procedures that will be followed in processing zoning petitions and amending the zoning ordinance. And then the last component for zoning is the zoning map. That's the actual map where you physically divide up all the property in your locality and give it its designation. This area is residential, this area is commercial. If you don't have a zoning ordinance, then you certainly won't have a zoning map. There are three bodies that work together that are partners in overseeing the local zoning ordinance. The first one is the local governing body. It's a legislative body. It adopts the zoning ordinance, it amends it, it reviews and acts on zoning applications, and it appoints the members of the Planning Commission. The second body is the Planning Commission. It's an advisory body. The Planning Commission is a 15-member body the members of which are appointed by the local governing body, and it's created to develop expertise in land use matters and make recommendations to the local governing body on zoning matters. All zoning petitions, all amendments to the zoning map have to go, and the zoning ordinance have to go to the Planning Commission before they can come to the local governing body. And the local governing body is not required to follow the Planning Commission's recommendations. It is simply an advisory body. And then we have the Board of Zoning Appeals. The Board of Zoning Appeals is a 5 to 7 member body, members of which are appointed by the circuit court judges in the locality, and it's created by state laws, and it has those powers and duties that are assigned to it by state law. And those duties, there are 4 possible duties for Board of Zoning Appeals. The first one is to hear and decide appeals from the decisions of the zoning official or the zoning administrator or zoning officials, their interpretation of the zoning ordinance, their enforcement of the zoning ordinance. And we'll talk about all of these a little bit more. Their second power is to grant variances, hear out and decide applications for variances, and to make interpretations of the zoning map. If there's any disagreement as to where a particular boundary one district starts and another one stops and it's unclear, the Board of Zoning Appeals is charged with making those decisions as to the proper interpretation of the zoning map. And then in some localities, and we'll again talk a little bit about this more in a minute, some localities have given their boards of zoning appeals the authority to issue special use permits, to do things that aren't normally allowed by the zoning ordinance. Like maybe allow an off-premise sign, somebody to put up an off-premise sign. Lynchburg has, most localities do not give their boards of zoning appeals that authority. Most local governing bodies reserve the authority to grant special use permits to themselves, and that's how it works in Lynchburg. The BZA only performs those first 3 duties. It doesn't make issue special use permits. Now, in carrying out its duties, the BZA is a quasi-judicial body. It's a kind of a unique body. It acts as and what that means is a Board of Zoning Appeals performs both legislative and judicial functions. When the Board of Zoning Appeals decides whether or not to grant a variance, it's performing a legislative function, just like the town council when the town council decides whether or not to grant a rezoning application. And when the Board of Zoning Appeals decides whether or not the zoning administrator's interpretation of the zoning ordinance is correct, the BZA is acting, performing a judicial function, just like a court does when it determines whether or not public officials are properly interpreting a law. Now, and we'll talk about this in a little more detail in a bit, unfortunately, sometimes the partners, the 3 partners that work together to oversee your zoning ordinance, don't always see eye to eye. Like, for example, sometimes the city council might not follow the recommendation of the Planning Commission on whether or not it should grant a zoning application or amend the zoning ordinance, and sometimes, but that's to be expected. Just like every other thing in life, people can have different opinions and there can be disagreements on what is proper in the administration and enforcement of the zoning ordinance. Now, hopefully that will be kept to a minimum and won't occur too often, but sometimes it does happen.
Quick question.
Yes, sir.
The ARB, where do they fit in?
Architectural Review Board.
Yeah.
Typically, an Architectural Review Board sits in if you have a historic district. The zoning ordinance allows, state zoning law, allows local governments to create historic districts in their localities to preserve historic buildings. And if you have a historic district, then you have an Architectural Review Board, because typically you cannot modify the exterior of a historic structure without getting a permit from the Architectural Review Board to determine that what you're doing with the exterior of a historical structure will not weaken its historic significance. So if you have a historic structure, if you have a historic district, and you want to make changes to the exterior of your building, if you want to put in new windows, if you want to replace the roof, even it can be if you want to paint it a different color, you need to go to the Architectural Review Board and get their sign off saying what you're doing will not compromise the historical integrity of the building.
Before you continue, I don't know if I could hop on in here, but I'd like to let these guys understand. We were talking about the three boards, the administrative, the planning commission, and the BZA, and who has power for special use permits and all of that. I'd like to try to give them a feel for how we're positioned here.
Oh, certainly.
So if I could talk with the zoning administrator, is that you or Thomas? Is Thomas taking that role? Or?
No, I am.
Okay. Where have we aligned the powers for that when it comes to like SUP permits?
So, generally speaking, we have a couple different application processes. If a business were to come in and file for a regular zoning permit, so that's something that is a by right use in our zoning ordinance, that stays within my authority as the zoning administrator to approve that. If somebody were to come in for a site plan application, then it goes through myself and the town planner for review, and ultimately it goes to the planning commission for a final approval. Again, that's a by right use that they are working on. If you come in for a special use permit, they start at the staff level, and then we put forward a recommendation to the planning commission. Planning commission holds a public hearing, makes a decision, and then they forward their recommendation to the town council, who discusses, holds a public hearing, and ultimately makes the final decision on that. If you were to do a zoning text amendment, zoning map amendment, that's the same process as a SUP. You're going both through the planning commission and the town council, with town council having the final vote. For an application like a certificate of appropriateness that we were just discussing with the ARB, similar, it comes through staff. We provide a recommendation to the ARB. They make a decision. If that decision were not to be favorable in the resident or property owner's eyes and they would like to make an appeal, they have an appeal process, and that goes to the town council. So that was a little bit more recent of an example would be the demolition of the Park House.
And so at this level, where do the appeals stop? So like an SUP, the appeal comes to us. And once that's done, then they have the right to go to the BZA for the appeal, right?
No, that goes to the circuit court.
That goes to this.
To make sure that these guys knew where
So-
the process rolled up and where it ends up falling into their lap as opposed to actually going to a litigation.
And I believe Mr. Irwin's you're gonna cover where the applications go, or do you want me to?
No, we're gonna
yeah.
cover that.
No,
What's that?
you know, with the Bean property, you know, where the BZA decided one way, the attorney decided to continue it, and so it's in Richmond court now.
Correct.
That just,
And-
like I said, I'm trying to get you guys to understand where the processes all end up, where it falls into your lap, where there's other direction in which things can go to continue with the appeals.
And we'll talk about the appeals process in a little bit, but as a general rule, if the town council makes a decision and somebody wants to challenge that decision to appeal it, it goes to the circuit court. When the BZA makes a decision, if someone wants to appeal it, that also goes to the circuit court. So the appeals process is very similar for both bodies.
Yeah, but he was talking about the SUPs in a generalized form. I just wanted to let you guys understand that. I don't think they ever see an SUP.
We never see any of that.
If-
The planning commission, I guess, does a good enough job that
Yeah,
we don't have to get involved.
Yeah.
Because basically,
But the
the planning
next step
commission
is
does
to
their job,
bypass you.
we never
and
do.
generally speaking, if I make a decision and it's appealed, you see it. So as a zoning administrator, but I'm sure Mr. Irwin will cover those items.
Okay.
Well, you're to be commended for being here tonight because training is important for BZA members. Because being a member of a BZA and understanding your job, it requires more than just longevity on the board, common sense, the wisdom that comes with life experience, or even having a deeply felt sense of what's right and wrong. All of those are great things to have, and all of those things will certainly help you in the performance of your duties. But, and they're valuable BZA members, but your role as a BZA is not intuitive. It's your responsibilities, your powers are very legal in nature, and BZA members have to know the applicable laws and rules that apply to it. And if any of you after tonight are interested in more training, there is a Virginia Certified Board of Zoning Appeals program where members of a Board of Zoning Appeals can attend this training program that is put on through state representatives, and you become a certified BZA member from going through the training program. It's a very good program. One of the reasons training is so important is because Virginia follows the Dillon Rule. Now, some of you may have heard that mentioned. Now, Judge Dillon was the Chief Justice of the Iowa Supreme Court, and back in 1873, he developed the Dillon Rule. And the Dillon Rule says that public bodies only have the powers that are expressly given to them by the state legislature. Now, the reason for the Dillon Rule is back in the late 1800s, that was probably the low point of local government operations in the United States. The railroads were coming through, and local governing bodies were cutting all special deals with the railroads to give away public land. You had the corruption in Tammany Hall in New York. Government was supposed to be formed to do good things, and Judge Dillon looked around and said, well, government isn't doing good things. It's misusing their powers. So the Dillon Rule is a way to limit the authority of public bodies. You only have the authority that the public body, that the legislature gives you. And if there's any question as to whether or not you have a public body has a particular power to do something or authority to do something, if there's any question, then it's decided against the public body having that authority. Now, there are only 7 states that still follow the Dillon Rule. Virginia is one of them. Other 43 states follow home rule. And in home rule, the situation is different. In a home rule state, public bodies have the authority to do anything except those things that the General Assembly has told them they cannot do. Public bodies don't like the Dillon Rule. They feel it limits their creativity. It's somewhat inflexible. But it doesn't look like, while it's been studied several times, it doesn't look like it's going anywhere soon. Interestingly enough, the Dillon Rule came from Iowa. When Iowa amended its state constitution back in 1968, it said, hey, we're scrapping the Dillon Rule. We don't want to follow this anymore. We're going to give our local governments more authority. We're going to a home rule state. Now, it's interesting. How the Dillon Rule got to Virginia is interesting. It's interesting to me because I lived in Winchester for a while and practiced law there for 4 years before I joined the city attorney's office. Back in 1892, evidently Winchester was flooded with arsonists. There were complaints about people running around setting fires. So the Winchester City Council said, well, we're going to offer a $500 reward for anybody who goes out and captures an arsonist. Well, a gentleman by the name of Mr. Redmond actually went out and caught an arsonist or two. He brought him down and then asked for his $500 reward, and the city council reneged. It said, well, you know, we're not really sure that we have the authority to use public funds to offer this type of reward. Mr. Redmond, he being the type of person who went out and captured arsonists, wasn't going to take that laying down. So he appealed that decision to the Virginia Supreme Court. And in 1896, the Virginia Supreme Court said, nope, Virginia is a Dillon Rule state. Public bodies only have the authority that's been given to them by the General Assembly. The General Assembly has never authorized cities to offer rewards for the capture of criminals or arsonists. So you don't have to pay Mr. Redmond his $500. Now, local governments wish that case had gone the other way, and they wish Winchester had paid that $500 because they've been stuck with the Dillon Rule ever since. But you know, Virginia is a Dillon Rule state, so you have to be aware of that, and when you're exercising your duties, you have to say, we really don't have much implied power. Just by existing, we don't have the implied authority to do much of anything. We've got to look in the state code, and that tells us the authority that we have and the procedures that we have to follow in exercising that authority. What are some of the rules and principles that a BZA needs to follow? Well, because of the Dillon Rule, the Board of Zoning Appeals is a creature of statute. It's created by the state laws, and its responsibility is to apply the state law and the local zoning ordinance. The BZA has no implied powers. It's one of the things that has come over the years, that the BZA is not supposed to base its decisions on sympathy. Somebody comes in and throws themselves on the mercy of the BZA. BZA can't make decisions based on sympathy, fairness. It's not the BZA's role to decide whether or not the zoning ordinance is good, bad, overbroad, or unfair. It's the BZA's role to apply the local ordinances in following the procedures spelled out in the state code. In considering applications and appeals that become before the BZA, the burden of proof is always on the party filing the application for the appeal. And generally, that's not going to be the town. It does happen occasionally. I was with Lynchburg for 41 years, and we only had like 3 decisions where the town challenged the BZA's decision. So the burden is on the person who files the applicant to demonstrate that they meet the requirements of the law. Also, decisions, the Virginia Supreme Court has said that public bodies or public officials that are charged with administering, interpreting laws, their decisions are to be given great weight. And a decision of the zoning administrator is presumed to be correct. Now, that doesn't mean it's not, the Board of Zoning Appeals doesn't necessarily have to accept it, but when it comes before the Board of Zoning Appeals, the burden is on the person appealing the zoning administrator's decision to convince the board that that decision was incorrect. And there's a presumption that it was correct. And that's a good presumption because, and we'll talk about it a little later, if somebody appeals your decision, the Board of Zoning Appeals decision to the circuit court, then your decision is also presumed to be correct. And the burden is on the person challenging your decision to demonstrate that the board's decision was out of line. So if you think a case, this is a really close case, it could go either way, then you should deny the appeal. The person hasn't met their burden of demonstrating, the person filing the application has not met their burden. Board of Zoning Appeals decisions have to be made within 90 days of an application being filed. And the time frame can be extended if the Board of Zoning Appeals and the applicant and the town consent to the extension. One of the reasons they have a time period is because the local town has an interest in seeing for the proper enforcement of the zoning ordinance. And when appeal is filed, enforcement of the zoning ordinance is put on hold pending the outcome of the appeal. So you don't want appeals, applications, excuse me. You don't want applications before the BZA dragging on for too long. You want them to be made in a timely manner. State code says 90 days they should be made within 90 days unless everybody involved agrees to a longer time period. In making certain decisions, usually when you're a body, a quorum, if they're in the BZA, your BZA has 5 members, so a quorum is 3 members. In most public bodies, you need 3 members to show up, and then a majority of the quorum can then make decisions. But for the BZA, certain decisions have to require at least 3 votes, not just a quorum. Decisions on variances, whether or not to grant a variance, a decision whether or not to overturn the decision of a zoning administrator or zoning official, they all require 3 votes. So if you have a meeting and only 3 members of the BZA show up, and it's a 2-to-1 split, you have to wait and carry it over and vote on it again, because it requires 3 votes, positive votes, to grant a variance or overturn a decision of the zoning administration. During its hearings, the Board of Zoning Appeals has to offer an equal amount of time to both parties. One of the things that somewhat frets, and this always fretted the BZA in Lynchburg, a BZA, doesn't have its own staff. Now, a locality can give a BZA funds, they can appropriate funds to the BZA, to hire secretaries, clerks, and attorney, consultants, and other technical and clerical services, but very few communities in Virginia give their BZA funds to do those things. Instead, in most communities, Lynchburg, like Haymarket, city staff, the town staff will serve as a liaison. They will put together the agenda, do a lot of the work for the BZA. One misunderstanding that does come up from time to time is the town attorney does not serve as the legal counsel for the Board of Zoning Appeals. That came up a time or two in Lynchburg. The BZA would say, well, exactly what's your role, Mr. Irwin? And I finally had to write him a memo kind of spelling it out. The town attorney will come before the BZA. They'll explain to the BZA the town's position on a zoning matter. They will give guidance to the BZA on procedural matters. But they're not an attorney in the traditional sense, for the BZA. They are the attorney, for the town. Another guiding principle for the BZA is when you have a matter that comes before you, a request for a variance, an appeal of a decision of the zoning administrator, you're not supposed to have ex parte communications with the parties who are involved in that. And what I mean by ex parte communications, you're not supposed to talk about the key issues in the case with the people who are involved. Like the landowner shouldn't come to you and to say, hey, I need to tell you exactly what's going on with this appeal. Everybody should hear everything together at one time. So the BZA staff shouldn't do that, and I'm sure staff knows they're not supposed to do that. Property owners aren't supposed to do that either. You're not supposed to take the BZA members aside outside of their official meetings and discuss, what's going on in the case. Everything should be presented formally.
Can I ask a question?
Yes.
Yeah. So, and if that were to happen, what if we run into somebody at Wegmans and, an applicant sees us and says, oh, hey, I know the meeting's next Tuesday night, can I share this with you? In my mind, I'm walking away, but is there any legal or other repercussions for that?
And what we always tell the council members, the school board members, the BZA members, planning commissioners, say, look, I can't, I understand, I know this is an important matter to you. I don't want you to think I'm being abrupt, but I can't compromise my ability to make a fair, impartial decision by discussing with you one-on-one. Everything needs to come out together before all the board members are there, and everybody has a chance to hear exactly what's being said. So I'm not being rude, but I just can't discuss this with you because in doing so, I might compromise my ability to, or give somebody a chance to question my
Are we obligated to
impartiality.
report such contact?
There's no
to-
requirement that
Okay.
you have to report that.
Okay.
And in fact, you know, if you just handle politely, and that would be it.
Yeah.
Well, hold on. It used to be, Haymarket used to be a small town, you know, where everybody knew everybody. Everybody knew everybody's business.
Yeah.
And if you've been around here long enough, you know the old people's business. You don't know the new people's business, you know, because the town's grown exponentially. So we were approached with a case where I knew the guy who was playing. And you talk, you know, so it's wrong for me to talk to people now.
It's not wrong for you to talk to people, but when you have an application before you, it's not really appropriate for you to get information, discuss the merits of their appeal, either their appeal or their application outside of a formal meeting, because you are getting information that your other board members aren't having. The city staff isn't hearing the information that's being provided, and they don't have a chance to respond. It's okay to know what people's business is.
Based on 40 years ago,
Well, and
whereas these people just moved in 20 years ago.
yeah, and you can provide it in your meeting. That's when you provide it. As a body, you have a responsibility to say, hey, as a body, we act not as individual members. We act as a unit. And you need to, this is good information you're telling me. You need to write it up in a letter and send it to the secretary, and they will get it to all the members of the BZA. Or you need to come in and tell it to us. But as a single member of the BZA, I don't have any authority to act on behalf of the BZA, make any decisions. We act as a body, so you need to come down and do it. Again, you don't want to be rude to people, but you don't want to lead to challenges. Well, you know, they discussed this in secret, and give somebody a chance to question, you know, your impartiality.
Is there a similar provision? Is it a violation of Open Meetings Act that we couldn't talk about something outside of a formal meeting as well?
We're going to talk about the
Okay.
Freedom of Information Act in just a bit. There are a couple key issues of that I want to just mention. So let's talk about the powers of the BZA. One of the powers is the authority to review decisions of the zoning official and the zoning administrator and other zoning officials. That power is expressly given to the BZA by state law. You know, zoning officials have a lot of authority to make decisions that impacts people's property. And a lot of times people might not like a lot of those decisions. Some of the appeals that you may hear will center on things such the meaning of a particular zoning regulation, whether or not a particular use is permitted within a particular zoning district, whether a proposed structure complies with the setback, height, bulk, and other zoning requirements, whether or not a use is a non-conforming use, whether a property owner has vested rights, you know, whether a lot meets the minimum zoning size requirements, and whether or not a structure or use is violating the zoning ordinance, whether or not somebody is doing something that the zoning ordinance says, you know, they can't do. A common type and it's pretty common these days for if somebody is going to particularly start a business, they will want a decision from the zoning administrator. Is what I am doing before I spend money signing a lease or building a building or announce I'm opening a business. They want an opinion from the zoning administrator saying, is what I'm proposing to do, is that allowed under the zoning ordinance? Will that be legal? Another common appeal to the Board of Zoning Appeals is a notice of violation. The zoning official, if he or she believes somebody is violating the zoning ordinance, they send them a notice of violation saying, what you're doing is not allowed under the zoning ordinance, you need to stop. that can also be appealed to the to the Board of Zoning Appeals. An appeal must be filed within 30 days after the zoning official's decision is made. The person that appeals to the BZA has to actually be aggrieved by the decision. They have to have some interest in the decision. And an interest means a special interest. It means more some monetary interest or their next door neighbor, some interest beyond that just enjoyed by the general public. For example, a couple years ago in our mall, a company called Sequest wanted to come in. Sequest is pretty neat. They have sea animals and fish, and they put them in big aquariums, and you go through and walk through them and see them. And the question came up, was that a permitted use by right in the mall? Could they open that, or did they need to go through the zoning process and get a special use permit? And the zoning administrator said, no, that's a permitted use. We allow lots of commercial uses in the mall. This one doesn't require any special permit. Well, there were a group of animal rights activists who didn't like that decision. They think it's wrong to keep marine animals, in aquariums and exhibit them to the public. So they wanted to appeal that decision. But no, you don't have a special interest. You're not another tenant in the mall. You're not adjacent to this business. Your only interest is a member of the general public, and that does not constitute being an aggrieved person. The fact that you don't like it, you've got to show some special interest, how that is going to impact you more than it impacts the general public. After the notice of appeal is filed, the zoning administrator transmits all the records to the BZA. The filing of an appeal stays zoning enforcement action until the BZA has made its decision. The BZA must fix a reasonable time for the hearing as when it comes in. The BZA, under the Freedom of Information Act, this is a public hearing. Notice has to be given to the public that the BZA will be hearing this matter, this appeal, and the public has a right to come and attend the meetings and record the meetings if the public wishes. Prior to the hearing, any materials that are filed have to be given to everybody, and no cost to the applicant, but everybody gets all the information. What the city stuff is, and both the party, the applicant, city staff, everybody gets all the materials. During the hearing, each side should be given equal time to present their side of the case. At a hearing, the zoning administrator or the zoning official who made the decision is required under state law to explain the basis for their decision. And when the BZA has the authority to uphold the zoning official, to overturn the zoning official's decision, or to modify the zoning official's decision. The BZA's decision, state code says, shall be based on the BZA's judgment of whether the administrative officer was correct. So the burden, and there is a presumption that the zoning official's decision was correct, and the burden is on the applicant to convince the BZA that it was not correct. As we mentioned, the time period for this process is 90 days. Then the BZA, in deciding whether or not to uphold or modify a decision of the zoning official, is required to make findings of fact. You just can't say, let's do it. You've got to spell out exactly why you think the zoning official's decision was incorrect. Those findings of fact have to be part of the record. So in case there's an appeal to the circuit court will know what the basis of the BZA's decision was and be able to review it. Now, interestingly enough, there is a provision in the state code that says if the BZA's decision in hearing an appeal from a zoning official's decision results in a tie vote, the matter shall be continued to the next meeting upon the request of the person filing the application. Because a tie vote, and this comes up a lot of times in procedure, the local governing bodies, well, the city council, it seemed whenever there was a tie vote, they'd always turn to me and say, what do we do now? And I was always tempted to say, beats the hell out of me. But that probably wouldn't have gone over too well. But a tie vote doesn't do anything. If somebody's asking you to overturn a zoning official's decision and it's a tie vote, that means the zoning official's decision stands. If somebody's asking for a variance and there's a tie vote, that means they don't get the variance. You have to have a majority voting in the affirmative matter. But when it comes to overturning decisions of the zoning officials, if there's a tie vote, the applicant can say, I would like to have this matter continue to the next meeting because there's probably a tie vote because someone wasn't here, since you're a 5-member body, so everybody can be there and you can vote on it again, and hopefully it won't end up in a tie break. If the
At that point, if the applicant, if it's a tie, does the applicant have to pay more money?
No, the applicant doesn't have to pay more money, but the applicant has to say, I am requesting that this be carried over to the next meeting. If the applicant doesn't make that request, then that's the end of the matter. It's been disposed of, and it doesn't come back again unless the applicant files another application. Let's talk about variances. I mentioned that from time to time, the participants in the zoning process don't always see eye to eye. And I guess this was the area that is probably the most sensitive is when the BZA grants variances, because what the BZA does when it grants a variance is it's allowing somebody to do something that's not allowed under the zoning, ordinance. During the time I was with the city, 41 years, the city filed 3 appeals of its BZA's decision, and they all involved variances where the BZA had granted variances and where the cities felt like this didn't meet the standards, the proper standards for a variance, and we'll go through theirs. Now, variance is a reasonable deviation from the provisions in the zoning ordinance regulating the shape, size, or area of a lot or parcel of land, or the size, height, area, bulk, or location of a building or structure on the land when the strict application of the zoning ordinance would unreasonably restrict the utilization of the property. So variance requests that do not pertain to the shape, size, or area of land, or the size, height, area, bulk, or location of a building really aren't appropriate. If somebody's asking for a variance, it's got to be tied into one of those categories. For example, a common request for a variance that you'll see is a business will come in and say, gosh, I'm going to open my new fast food restaurant, but the zoning ordinance says I have to have 30 parking places, and I only have 20 parking places. I need you to give me a variance allowing me to just get by with 20 instead of the required 30. That's not a proper request because that doesn't really relate to the size, height, area, bulk, of the land. That's something else. And a variance is referred to as an escape valve to deal with situations in which the strict application of the zoning ordinance would unreasonably restrict a property owner's ability to use their property. Being able to grant a variance gives some flexibility in a zoning ordinance by protecting the property owner's rights, but without undermining the overall viability of the zoning ordinance itself. Because a variance allows a property owner to do something that's otherwise not permitted under the zoning ordinance, state law says the requirements for a variance have to be strictly met. You have to follow it, and you have to give it your decision has to be based on the proper factors. It can't be based on the fact that the sympathy for the applicant, well, we just feel sorry for you. And it can be based on the fact that the BZA might say, well, that's really an unreasonable provision in the zoning ordinance. That really shouldn't be in there. BZA does not have the authority to rewrite the zoning ordinance. That's the authority of the town council. Every application, almost every application for a variance will turn on whether the zoning ordinance is applied to when it's applied to a particular piece of property, will produce a hardship that unreasonably restricts the use of the property. And I'm going to give you some examples of variance requests where the Virginia Supreme Court has said these requests are not a proper basis for a variance. Where a property owner wants to build a larger deck than is allowed under the zoning ordinance because the property owner says, well, I entertain a great bit and I need a bigger deck so I can have more people over for more enjoyment of my property. That is not a proper basis for a variance. Another one is where a property owner wants to build a fence that's taller than that permitted by the zoning ordinance. That's for more privacy. That's not a proper basis. Virginia Supreme Court said you can't grant a variance for that. Where a property owner wants to build a garage closer to the boundary line than the setback lines in order that it'll be a straighter shot so they can get their car in and out of the garage more easily. That's not a proper basis for a variance. Where the property owner wants a variance so they will not have to comply with all the requirements that go with building a structure in a floodplain because it's really expensive to comply with those requirements and it will be financially burdensome. That's not a basis, for a variance. Where a property owner wants a variance so they can build an additional townhouse unit on their property for increased profitability. The ordinance says I can have 2, I want 3 to cover my cost. And the last one is where the property owner doesn't want to comply with the setback requirement. They want to move their house further towards the back of their lot so they have a better view of the ocean, more scenic view of the ocean or the mountains. The court has said none of these requests constitute, unreasonable hardship. These circumstances, the property owner wants a special privilege to do something that's not otherwise, allowed. So you have to keep that in mind, that the standards for granting a variance are very strict. What is the variance process? Well, it's really similar to the process that you use if you want to appeal a decision of the zoning official. The variance starts with the filing of an application for a variance with the zoning administrator. The application, the maps, plans, other document is then transmitted to the BZA. After receiving the application, the BZA must fix a reasonable time for the hearing. Under the Freedom of Information Act, the BZA has to give notice of the hearing and let the public, attend. During the hearing, prior to the hearing, any materials that are received have to be distributed equally to the parties. There's no secret information. Everybody who's participating gets all access to the information. During the hearing, equal time should be given to each party in fairness. Again, at the hearing, the burden of proof is on the applicant. The applicant has the burden of proving that his application meets the standards for, a variance. The whole process, the decision is supposed to be made within 90 days. And the BZA may impose conditions on a variance. If somebody comes in and says, well, I can't comply with the setback requirements because my my lot is of an unusual shape. It's not a square, rectangular. It's kind of pie-shaped or something. So I can't meet the setback requirement. That would be one related to the unusual shape, size of the property. That would be a legitimate request for a variance. But if the Board of Zoning Appeals has the right to impose conditions and say, if we grant you that variance that allows you to build closer to your neighbor's property, you need to put up some type of buffer. Might be a fence, might be landscaping to protect the privacy of the adjacent property owner. And the Board of Zoning Appeals has the authority to require the applicant who's being given that variance to post a bond to make sure that they put in, that buffer to protect the adjoining, property owner. What are the requirements for variance? I do want to talk to me. Sometimes when you go to a Chinese restaurant and they give you the menu and it says choose one from column A, choose one from column B, that's kind of like the variance, process. The column A is when you look at the requirements for granting a variance, you have to find that one of 3 conditions are met, the column A requirement. You have to find that Either the strict application of the zoning ordinance would unreasonably restrict the use of the property. For example, the example I gave you was the property owner who wanted a variance request from the setback requirements in the rear of their house because they wanted to move their house back further so they would have a better view of the ocean. Not getting a variance for that is not an unreasonable hardship. So you have to find that either one, the strict application of the zoning ordinance would result in an unreasonable hardship, or two, the granting of the variance would alleviate a hardship due to the physical condition relating to the size, shape, or area of the lot or parcel of land. An example of that would be the zoning ordinance, and Lynchburg had this problem come up. Our zoning ordinance says if you want to build a residence or a business on a public street, you've got to have 50 foot, your lot has to have 50 feet of frontage on the public street. Well, I might have a lot that because of the unusual shape, like the lot my house is on, the front of the lot is more narrow than the back of the lot. So the property owner comes in and says, well, I can't meet that 50-foot requirement because I only have 40 foot of frontage on my lot. In that case, the hardship is being caused by the unusual size, shape of the lot. And if I'm not allowed, can't get a variance, then I can't build on my lot. So that would be an unreasonable hardship. So in that case, a variance would be, appropriate. Or the third requirement that you have to pick one of these three, the granting of the variance would alleviate a hardship by allowing a reasonable modification to the property or improvements on behalf of a person with a disability. So if a family comes in and says, we need to build an extension on our house to house a person with a disability, it might be an elderly relative who has a physical disability, it might be, say, a child or who has a condition that they can't go out and live on their own, and you say, well, our zoning ordinance doesn't allow it because you couldn't comply with the setback requirements. In that case, a variance is appropriate to accommodate a request that would allow a person with a disability to be able to make use of the property. So that's kind of the column one. When you decide to grant a variance, you've got to find one of those conditions exist. You also have to find that all of the following 5 conditions exist. That the property interest for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant for the variance. We had this come up in Lynchburg a couple years ago. A developer went out and put in the foundation of a house, and he violated the front setback, he violated the side setback. And then after he'd done that, and the zoning official and the building code official caught him, he said, well, I want a variance. That's not a proper request for a variance because that was a condition that was created by the property owner, or in this case, the developer, not complying with the zoning ordinance. It's their responsibility to know what the requirements are. And even though they may have made an innocent mistake, that doesn't entitle them to the variance because they created the hardship that they're seeking relief from through their own carelessness or negligence in not making sure they knew what the zoning requirements are. You also have to find that the granting of the variance will not be of a detriment to adjacent properties or nearby properties. Typical of that gets back to the restaurant who comes in and says, I can't meet the parking space requirement. I need a variance so I won't have to put in as many parking spaces. The Virginia Supreme Court has said overflow parking and congestion is a substantial detriment to the other property owners. If you grant them the variance, then the customers are likely going to be parking in front of the adjacent property owners' businesses or properties. So, that granting that variance would have a negative impact on the adjoining property owners. So that's not proper. So you've got to find that granting the variance will not have a substantial detriment to the adjoining property owners. You also have to find that the condition for which the variance is being sought is not of a general or recurring nature, that it's limited to one particular piece of property. For example, the owner of a piece of property in a subdivision lot in Alexandria wanted a variance to build a house that would violate the setback requirements. But the Supreme Court said, well, they can't get it because when you look at that subdivision, 2/3 of the lots in that subdivision, 1/3 of the lots in that subdivision are all the same size. This is not a variance for a condition that's limited to a particular piece of property. This is a situation that is of a general nature. It applies to multiple properties. So the proper remedy is for the property owners to go to the local governing body, the Alexandria City Council, and get an amendment to the zoning ordinance that would reduce the size of those lot size requirements. You also have to find that the condition or situation of the property is not, that's one. The fourth one you have to find is that granting of variance does not result in a use that is not otherwise permitted on the property. You can't rewrite the zoning ordinance by allowing somebody to do something that the zoning ordinance says you can't do. For example, property owner comes in and says, I want to divide my property into 2 lots so I can build 2 houses on it, but once I subdivide my property, the 2 lots won't be big enough. They won't meet the standards in the zoning ordinance for proper lot size, so I don't have enough acreage, so I want a variance. Granting the variance in that situation would be, in effect, rezoning the property to allow a more intense use. The zoning ordinance says 1 structure on a lot, and if you granted a variance that said you can have 2 structures on lots that don't meet the size requirements, that is in effect, rewriting the zoning ordinance, and you don't get to do that. And then the 5th condition is the remedy that's being sought through the variance is not available through a special use, permit or condition. Sometimes you'll get people say, well, gosh, I know I could get a special use permit from the city council, but I don't want to go to the city council. They're unreasonable. I'd rather come to the BZA. If somebody is asking for a variance for a condition that can be corrected by getting a special use permit from the governing body, they've got to go to the governing body rather than coming to the BZA. Unlike the decision that the BZA makes when it is reviewing a decision of the zoning ordinance, zoning official, BZA is not required to make specific findings of facts when it grants a variance. It doesn't have to spell out the reasons. Now, I recommend that you do so because, one, if you go through that list, that menu list, and say, here are the conditions that we find, one, it makes sure that you followed all the requirements, that the requirements are being met, and two, if your decision is appealed, you've created a record that the court can look at to say, yep, the BZA got this right. It's right here in the record what the BZA's findings were, what the basis of the decision was. Without that decision, it may be harder to justify your decision. There's also some special exceptions. We've mentioned one of them, that you have to make special exceptions in your zoning ordinance for. The BZA can. There's 3 special situations where rigid compliance with the zoning ordinance can be superseded. One, when variances are sought as part of the Condominium Conversion Act, a Virginia law that says properties being converted to condominiums. Sometimes you may have to grant variances that you would not otherwise grant to make the conversion to the condominiums possible. One is the Americans with Disabilities Act. That's a federal law that says every locality, it may have a zoning ordinance, but you've got to make reasonable accommodations for persons with disabilities. And then the third one is the National Flood Insurance Program that says if you've got somebody who's going to build in a floodplain, you may have to make special accommodations for them in order that they can comply with the requirements of that National Flood Insurance Program. The other two decisions I mentioned, I was with the city of Lynchburg a long time. We never got a request for the BZA to interpret the zoning districts on the zoning map. That issue never came up. But if you do get it, the process would go the same way. Somebody would call, file an application saying, I've been told that my property is in a residential district. I think the residential district stopped, half a mile down the road. I think I'm really in a commercial district. There's confusion over the districts that have been drawn on the map. I need you to sort it out. And the BZA would have that authority. The other one we talked about, the interpretations of the zoning map district boundaries. That is one of the authorities, duties you're given by state law. And then the third one is special use permits. And that's, as we've already talked about, Haymarket has not granted, just like Lynchburg has not granted the BZA the authority to issue special use permits. Appeals to the circuit court. Someone who's aggrieved by a decision of the BZA can appeal it to the circuit court. Again, to be aggrieved, you've got to have some special interest. An adjacent property owner, a member of the general public just can't come in and say, I didn't like this decision, I want to appeal it. They've got to have an interest, a financial interest, a proximity interest, something that is more specific than just being a member of the general public. The petition for certiorari, that's what it's called. If you want to appeal a decision to the circuit court, you file a petition for certiorari. It has to be filed within 30 days of the BZA's decision. The BZA is not a party in the lawsuit. The BZA's only responsibility once an appeal is filed is to send all its records to the circuit court, in a timely manner. The parties to the case are the locality and the property owner. It's just like when you have a court case and the court's decision is appealed, the style of the appeal is Smith versus Jones. It's not somebody versus the circuit court that made the decision. And as we talked about, there's a presumption that the BZA's decision was correct, just as there's a presumption that the zoning official's decision is correct. And the party filing the appeal has to convince the court by proper evidence that the BZA's decision wasn't correct. So that's why it's a good idea to make a record, because that helps the court find that the decision was based on legitimate findings. That's why decisions of the BZA on matters don't go into effect until 30 days after you make the decision, to give someone a time to appeal if they want to. So that is kind of the appeals process. It's very similar for the same process that the town council would follow if somebody wants to challenge the town council's decision on a zoning matter by appealing that. For the last part of tonight's discussion, I want to touch on a couple topics that aren't specifically part of zoning, but they impact the BZA's decision. First one I want to mention is rules of procedure. Now, rules of procedure seem to have a bad image these days. You mention rules of procedure, Robert's Rules of Order, and people kind of make the sign of the cross and all move away from you. There seems to be a view that rules of procedure are what those city slickers use to take advantage of all us good folk. Rules of procedure, that is really contrary to the purpose of rules of procedure. They certainly can be abused. And if you look at the federal government and the state government, they're always abusing the rules of procedure. But at the local level, for local public bodies, the rules of procedure help you run your meetings fairly and efficiently, because you have the right to not monopolize your time and do that. So I want to suggest that you consider adopting some very rules of procedure. I gave the clerk a copy of the Chesapeake Rules of Procedure. They're one page, and they just say things like, it starts out, the process for our meetings will be the secretary will announce for the record that a quorum is present. They will announce that the application is for this particular subject. They will then turn it over to the chair. The chair will then let the applicant speak, the person who filed the application, they get to speak. Then after they have spoken, the chair will let the city staff members speak. After that, then the chair will open up to comments by members of the general public. After the public has spoken, then the members of the BZA will ask questions, that they might have about staff or the property owner. After the BZA's questions have been answered, then motions will be made by the BZA to either approve or, disapprove the application. Chesapeake's Rules of Procedure are one page long. Now, I know you all don't have a avalanche of applications to consider, but what I have found after doing this for a long time is that suddenly, and zoning can be very emotional, suddenly you'll have a really bear of a hearing and you don't have any rules of procedure to follow. And citizens want to know, well, what are the rules? If you've got rules of procedure, where are they? What are they? A lot of public bodies simply say, well, we'll follow Robert's Rules of Order. The reality is nobody follows Robert's Rules of Order. It's over 600 pages. A lot of the stuff that's in Robert's Rules of Order, it doesn't even apply to public bodies. So having a one just simple set of rules of procedure that say this is what we'll follow, particularly since you don't have a lot of meetings, it gives you the guide to turn to help you through what and it could be a contentious hearing, because zoning applications, zoning matters can get very contentious. So I would strongly recommend you take a look or think about adopting rules of procedure.
So a couple of questions. So the BZA has no rules of procedure right now, is that true? Correct. Okay. Does the BZA have authority to adopt those, or is that
yes.
council that would do that?
The United States Supreme Court has said that all public bodies have the inherent right to adopt rules of procedure to help them run their meetings in an efficient and orderly manner. So you don't need permission from...
Great. And the third question would be, around that would be, are those rules subject to review by any other body? Circuit court, town council? Okay.
Not subject to review. In addition to the rules of procedure are how you're going to run your meetings. This is the order, these are the motions. And one of the things you might want to consider is placing time limits on speakers. Because it can be very tough if somebody gets up and starts rambling, if you don't have time limits to cut them off. City Council in Lynchburg, under its rules of procedure, it says, we will give the applicant 15 minutes. Then we'll give the zoning administrator 15 minutes to give his, and then we'll let citizens, anybody else who wants to speak, if they get 3 minutes each, and then the chair will tell them, hey, you're running out of time. Because citizens always want to say, if you tell them, well, you've got to stop speaking, well, show me your rule of procedure, or show me where it says that. If you're worried about that, it's a good idea to have that in place.
So a fourth question would be, if you don't follow the rules and procedures that you've adopted, does that become grounds for an appeal?
No. Okay. There's a court case several years ago, actually a zoning case, where the court said, these rules are for the benefit of the public body to help them conduct its meetings in an efficient, orderly manner. If they fail to follow them, that doesn't give a third party the right to challenge the BZA's decision. So as long as you've got a proper quorum, as long as you the majority vote, you're okay. There's Virginia cases from the Virginia Supreme Court that says the failure of a public body to follow its rules of procedure is not a basis for overturning its decision, as long as it met the real laws that have to have a quorum. Another thing I would think you might want to talk about is bylaws. I also gave a copy of some bylaws to the clerk. The bylaws are the things that say, this is how we'll meet, We might have one annual meeting, say in January of the year. We'll also meet anytime we got to have an application. At our first meeting, we'll elect our officers. We'll have a chair. We'll have a vice chair. When the chair isn't there, the vice chair will preside. We will hold our meetings on Tuesdays, in the evening. That's just kind of how the board is going to structure itself. I think bylaws are also, when questions come up, when you get a new member, how do we operate? Having the bylaws to give them, that lays it all out is a big help, I think. So I would, even though you might not need them that much, I would say adopting bylaws, adopting rules of procedure for your meetings will make you a better board. And it's not intended to encumber the board, to trick the board, to burden the board. It's just to help the board know where things stand and to be able to run its meetings in a more efficient and timely manner. Because citizens don't have a right to get up and speak as long as they want. The board has a right to say, we're busy people, we're volunteers, we've got a lot of other things to do. That's why we're going to place time limits on how long citizens, get to speak. Even if you have those, you may be prepared that sometimes people will get up and think they can speak as long as they want anyway. It can be difficult at times to get people to be quiet. Also wanted to check on mention the Freedom of Information Act. That question came up. Now, the Freedom of Information Act is, as you all know, is a Virginia law that deals with public meetings and public records. It's been around since 1968. It says that all members of public bodies are responsible for knowing and following the requirements of the Freedom of Information Act. And it has two main parts. The first part deals with public meetings. The second part deals with access to public records. Why do we have the Freedom of Information Act? Well, we have it because there is no constitutional right, either at the federal constitution or the state constitution, for citizens to attend meetings of public bodies or get access to public records. So since there's no constitutional right for that, the state has adopted the Freedom of Information Act to spell out those rights for citizens. All 50 states have Freedom of Information Acts, and the federal government has one. So all governmental entities these days have these laws. Who's covered? All public bodies and public officials, and you certainly fall into, to that category. The things I want to mention is I mentioned earlier that when you hold your meetings, you have to give notice what time and the meeting's going to be held, what you'll be considering. Public has a right to attend and observe. Public also has a right to record the meeting if they want on their cell phones, their cameras. Freedom of Information doesn't give citizens the right to get up and speak at the meeting. It just says they have the right to come and observe. It doesn't give them the right to actually participate unless they're the applicant. What I wanted to caution you about is that the Freedom of Information Act says when more than 2 members of a public body get together to discuss a matter, that is a public meeting, and it's subject to all the requirements of the Freedom of Information Act, giving notice, keeping minutes, all of those things. So 2 of you can get together if you want to and talk about an upcoming zoning application. Once that 3rd party joins in, that has become an illegal meeting, and you have to be careful about that. The other thing you have to be careful about is electronic communications. There have been a number of court cases on that. I used to call them, well, I'm outdated and I don't use social media. But if you are communicating simultaneously, more than 2 of you, so if you're in the old days, you used to call them chat rooms. So if 3 of you are in a chat room, that has become, even though it's an electronic and you're not physically together, that is a meeting. And it is an illegal meeting. Now, it's okay to send board members emails and to everybody, because the court has said that's just like putting a letter in the mail. But if you're all at your computers or your smartphones at one time, and there is a simultaneous exchange of discussion and information, then that has become a public meeting. And you have to be careful of that. Some officials have gotten themselves in trouble by unknowingly holding public meetings just by having those type of electronic discussions. Now, social events, they're not public meetings. All of you might show up at a fundraiser or a charitable activity or community event. That is not a public meeting unless three of you drift off into the corner and start talking about that upcoming, zoning application. Then it becomes a public, but it didn't start out as a public meeting, but once three of you started to discuss public business, it became one. The other thing I want to mention is public records. The Act says that public records should be made available, to the public. It makes that broad statement. Then it walks it back because there are 136 exceptions, last time I counted, in the Freedom of Information when they say, well, these type of records you don't have to give out. Personnel records, legal opinions, that type of thing. But any communication you have, writings, recordings, handwriting, typewriting, printing, photostating, photograph, magnetic impulse, electronic, anything you communicate, either traditional methods, writing, printing, or electronically, text messages, emails, all of those, if they relate to city business, your business, public business, then they are public records. You have to save them. You have to, produce them in response to a Freedom of Information Act request, unless it's exempt, unless it falls within one of those 136 exemptions. If you have problems with that, the clerk can help you. She can talk to the town attorney and get some guidance on that. What the biggest problem I've seen with public officials and public record requests is they let them lay around and they don't respond in a timely manner. The Freedom of Information Act says you have 5 work days to respond to a request. Citizen doesn't have to say, I'm requesting records under the Freedom of Information Act. All the citizen has to say is, I would like copies of certain, records, documents. That alerts you that that's a Freedom of Information Act request. You can't require that the request be in writing. Some people will say, well, I'll send you the stuff, but you send it to me in writing. The Act says you can't require that. Now, what I found citizens would do when they would call in and say, I want something, I would say, well, would you mind sending me an email or a letter just so I understand what you want and I can get you the records you're actually looking for. And I never had a citizen who got snarky and said, no, I'm not going to do that. The people usually say, yeah, that's good, and they'll do it. But you can't require it in writing. You can't say, well, I'm not going to send you anything until you send me a sitting request. Within 5 work days, you've got to either, 1, produce the records, 2, tell the citizen, hey, what you're looking for doesn't exist. We don't have it. 3, you have requested these records, but these records are exempt, and here is a section of the Freedom of Information Act that says they're exempt, and we're not going to give them to you. And you have to cite the section of the Act that makes them exempt. If they've sent you in a request for an unusually a large amount of records, or the person that has the records, say the clerk is on vacation or sick, you can say, hey, it's not practically possible to respond to your request within 5 work days. I'm invoking my right to claim an additional 7 work days under the Freedom of Information Act to provide the records. If you want to, the Act says you can charge the citizen for the cost of finding and copying the records. Some localities do that, other localities, do not. And their exemption, as I mentioned, the 136 exemptions in the Act. Some of them are for personnel records, legal opinions, if you've gotten advice from an attorney. But, the Act is pretty complicated. It's gotten more and more complicated over the years. So that's something, if you have a Freedom of Information Act question, you're probably going to want to talk to the clerk and get some guidance on that.
Well, that's my question now. So the application we heard, golly, when was that? 3 years ago? When was that? I've forgotten. 2020, 4 years ago. I don't know how time flies. The records were actually kept here, right? The minutes for the meeting, so we're not,
Yeah.
the board, so any FOIA request, really, we're going to go here. And the town attorney is not counsel for us, but isn't the town attorney going to advise the town staff with regard to the exemptions of a, so.
That's what the
so
town attorney does.
Even though you're training us,
Yeah.
I'm kind of like, la, 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 because it's all going to get handled here, isn't it? Okay.
And what, I guess the caution for you,
Okay.
and that's usually the way it works, that the staff's going to have that stuff.
Yeah.
But what officials often have to do is, you say citizen corners you in the grocery store and says, the citizen sends you a text message or an email.
We would have to produce those.
You would have to
So if it's on
produce
my cell
those.
phone or
Yeah.
that, we would have to then comply and get those records
And
to
that's
you all.
one thing you need to understand. It doesn't matter if you keep those records on a computer, tablet, cell phone, that's your private one, or one that's been issued to you by the town. If it relates to public business, then that is a public record regardless of where it is stored. In addition, there's also a lot of public officials, when you tell them that, well, they say, well, gosh, the way I'll solve that problem is, I'll just delete everything. If I get an email or a text message, I'm not going to keep it. There's also a law, the Virginia Public Records Act, that says, well, you can't do that. It doesn't do any good to have the Freedom of Information Act and give citizens the right to keep records if nobody's keeping any. So if you get those texts, if you get those emails that relate to public business, even though they're unsolicited, if citizens send them to you, you do have to hold on to those.
So as a practical matter, and this is like really unlikely this stuff's going to happen, but we would then, would somehow part of every meeting be, has anybody received communication from, could you bring those
And that would be
communications
something
to?
that you might want to develop in your bylaws.
Yeah, exactly.
If we
And then those get handed over right
if we
then
get
as
these,
opposed
we
to.
will send
Yeah,
them
okay.
within a certain time period. We will send them to the clerk, who will preserve them in response to Freedom of Information Act requests. The Freedom of Information Act doesn't have criminal penalties. If you violate the Freedom of Information Act, it's not a criminal violation, but it is a civil violation. You can be fined for not less than $100 or more than $1,000 for a first offense, not less than $500 or more than $2,500 for a second offense. If the court finds that you violated the Freedom of Information Act and imposes a fine, that can't be paid from public funds. That has to be paid by the official who violated the act. So you don't want to violate. In addition, if the court finds that it was a bad violation, the court can also order the public official to pay the person who filed the request their attorney's fees and court costs if they have to go to court to get the record. So it isn't something you want. It's not only embarrassing, and it's one of those things where you either like it or not by agreeing to serve on the board. The law says you'll be familiar with and you'll comply with the Freedom of Information Act. So you don't want to violate it. Last topic I want to touch on is the Virginia Conflict of Interest Act. Now, that is the law that regulates the conduct of public officials and public employees. And it basically has three main parts. One, it says you won't do bad things. You won't take bribes. You won't use confidential information you got from the performance of your duties for your own benefit. You won't participate in a transaction in which you have a personal, you or a member of your immediate family has a personal interest. It places strict regulations on the acceptance of gifts by public officials. That's probably not something that the BZA has to worry about. It's something the City Council really didn't have to worry about. But certainly Governor McDonnell, if you remember him, he really got in trouble a couple of years ago by accepting gifts. Again, this is a law like the Freedom of Information Act that says public officials are required to be familiar with the Freedom of Information Act, the Conflict of Interest Act. So and not violate it. Some of the things you can't do is, and you know these, solicit or accept money for the performance of your duties. Offer or accept money for the performance of your duties. Use confidential information you get in the performance of your duties for your own benefit. Accept gifts from sources that would give the appearance that you're compromising your impartiality and your integrity. The thing that can cause a problem is personal interest in a transaction. The Act says you can't participate in a transactions, any matter that comes before your body. A request for a variance, an appeal from a decision of the zoning official, if you or a member of your immediate family have an interest in it. So if you work for a company and the company that you work for files an application for a variance for one of their projects, you can't participate in that. If your spouse is employed by that company or owns, then you can't participate in that transaction. So, what constitutes a personal interest? If you or your spouse get a salary that exceeds $5,000 a year, if you have a 3% interest in the assets of a corporation, if you at least $5,000 worth of property, those are all things that if they come before you, then you shouldn't participate in that. You definitely do not want to violate the Conflict of Interest Act. Unlike the Freedom of Information Act, violating the Conflict of Interest Act is a criminal offense. And you can be fined up to $2,500. You can be sent to jail for up to 12 months. And if you're convicted of a knowing violation, you lose your seat on your public body. You're removed from your public body. Now, the good news is, because the violation of the Conflict of Interest Act is a criminal offense, you can get opinions from the Commonwealth Attorney. State law charges the Commonwealth Attorney with issuing opinions. So if you ever get in a situation where you think, gosh, do I have a conflict here? Is this something I need to check into? You can contact the Freedom of Information, you can contact the Commonwealth Attorney and say, I need an opinion. You can also contact the Virginia Conflict of Interest and Ethics Advisory Council. That was created, I guess 8 years or so ago now, in response to Governor McDonnell. And that body has the authority to issue opinions. The problem with getting an opinion from the council is we only met a couple times a year, and so you weren't going to get a speedy opinion from them. It would take months before when you came in a request to get an official opinion. If you get an opinion, though, from the council or from the Commonwealth Attorney, then you can't be prosecuted for violating the Conflict of Interest Act. You're acting on the advice of those parties who are responsible for giving an opinions, and you are, protected. So hopefully it won't come up, but if an application comes before you in which your employer or a client, this can come up. If, say, you're an engineer and the company you work for does business with somebody who files an application before you, a company, then you're probably going to have a conflict. So those are some of the things that come up. And then small community, where everybody's interconnected, Conflict of Interest Act issues can come up, fairly frequently.
Who determines that?
Who gives the opinion? Oh, the Commonwealth Attorney. Since a violation of the Conflict of Interest Act is a criminal offense, the Commonwealth Attorney is the one who determines whether or not the act has been violated.
And you have an issue of whatever kind, and I think it might be a conflict.
I will.
How do we determine if it's a conflict or not?
Well, if you think it's a conflict, then the best protection would be to abstain from voting and say, I might have a conflict. Virginia defines the Conflict of Interest Act as a financial interest. So if the person who comes in is simply your friend, your good buddy, even your neighbor, that's not a conflict. A conflict is you or a member of your immediate family have a financial interest, a stock, owned property, salary. It's a Virginia Conflict of Interest Act says it's not friendships, it's money. One thing I will tell you, though, is the Conflict of Interest Act sets the minimum standards. You can't go below these and do certain things or you'll be in big trouble. It doesn't prevent public officials from having higher standards of conduct. One of our mayors had been a professor at Lynchburg College, and then he retired and he was no longer a professor. But whenever a matter would come before City Council, a zoning matter involving Lynchburg College, he would always say, I've checked with the city attorney and I've been advised that I don't have an actual conflict because I no longer have a financial interest with Lynchburg College. But I know people will question whether or not I can be fair and impartial when it comes to making decisions regarding the college. So in order to avoid even the appearance of impropriety, I'm going to abstain from voting, on this issue. So I will tell you that one of the mistakes I made early in my legal career was I focused too much on what was legal, telling public officials, well, if it's legal, so you can go do it. Later on, I realized, it might be legal, but it might be stupid. Some of the dumbest things I've seen public officials do over the years were perfectly legal. And I'll give you an example, an actual example that I felt bad about it. Our planning commission, Liberty, Lynchburg Christian Academy, and Jerry Falwell's school in Lynchburg was very successful, and they wanted to accept more students, but they didn't have enough room, so they applied for a zoning permit, a special use permit, to put up some of those trailers, you see, so they could house additional students. One of the members of the Planning Commission came to me and said, look, I'm a member of Thomas Road Baptist Church. Do I have a conflict? Can I vote on this? And I said, well, do you get any money from the church? Or are you going to be impacted financially, economically by this decision? Well, absolutely not. So I said, okay, then you can vote legally. You don't have a legal conflict. You have no financial interest. This won't hurt you or harm you economically, help you or hurt you. But you ought to announce that you can be fair and impartial. You've checked, you've been advised, you don't have a legal conflict, that you can be fair and impartial, and you're going to vote. So he did. But then the newspaper lambasted him. The editorial in the newspaper said, he undermined the whole zoning process. Yeah, if he had enough sense to go and ask the city attorney if he had a conflict, he should have known he did. And who in their right mind would believe that he could be fair and impartial when it came to voting on a zoning application for his church? This was terrible, terrible conduct. So even though he hadn't violated the law, he really got lambasted in the press. And, I made a copy of that editorial. I kept several copies of it in my desk. And whenever a public official came in and said, hey, this is what I'm thinking about doing, I would say, well, you don't have a legal conflict, but you might want to read this article and think about it a bit before you go ahead, because you can still do something that's perfectly legal, but it won't play well in public opinion, in the public's eye. And in most instances, after they read that article, they said, well, you're right. I think I probably better abstain from this. Okay, that's the end. Any questions, comments, and heckling welcome. Just keep in mind you get what you pay for, and I'm doing this for free. So, but I'll be glad to try to answer any questions you might have.
Thank
I've
you.
got one question on the rules of procedure. Say we don't adopt any rules of procedure. Can we establish rules of procedure at the beginning of an appeal?
Well, once you've gotten through the process, well, you could. And by appeal, you mean somebody's filed an application.
Somebody's coming in here and we're
Yeah,
meeting,
you've.
we seldom ever meet.
Yeah,
So we can do this at the beginning, say, okay, this is what we're gonna follow. You're gonna have 20 minutes to talk, you'll have 20 minutes to talk, and everybody that's
Yeah,
concerned.
you can certainly do that. Remember, you don't have to schedule the hearing immediately. You've got 90 days, so if you get an application, appealing a decision or an application for a variance, and you think, well, this one looks like it might be pretty hotly contested, you could call a special meeting to adopt rules of procedure to cover your meeting on the appeal.
But based just for that appeal.
Well, you could adopt them and say, hey, you know, we probably should have had rules of procedure. We're going to adopt them for this meeting, and if they look pretty good, we'll keep them from now on. Or you could go to the process, every time you have one, you could re-adopt and take another look at the rules of procedure. You've got a lot of flexibility as the board as to how you want to handle that.
Just do that the next time we meet.
Once every
Sounds like-
5 years,
Yeah.
He says he gave
You know, I mean, 'cause I'm not gonna remember that.
Just write 'em down.
But can you send those to us so we can see the Chesapeake
Yeah.
and whatever else you had
I
indicated
think the two
and sample
documents,
that?
one was a one-page rule of procedure,
And
the
then
other was
bylaws?
their bylaws.
Yeah. Rules of procedure, yes, bylaws.
Yeah, I'm thinking we keep it simple.
And the bylaws don't have to be complicated. They just could say, our regular meetings will be on this day of the week.
Yeah.
We'll meet once a year.
Once a year, on Wednesdays at
At the first meeting, we'll elect our chair, our vice
Mm-hmm.
chair. Again, the rules, the bylaws do not have to be complicated. They just have to be very basic.
Yeah.
And
Yeah,
what we
Ken,
could
I think
do
we'll be
is
driving that.
you could establish your next meeting so
Mm-hmm.
that you could appoint your chair. I could present you with the draft of the rules and procedures and the draft of the bylaws. And then you could just go ahead and accept them right then and there, and it'd be done.
Or modify.
such a great group, and you
Thank you.
have a good evening.
Yeah, safe travels back.
Thank you.
Thank you.
I'm curious about what's the frequency? I mean, so I've been on since 2017, and I think we've met once. Has it been just the once,
Yeah.
I think, maybe?
I've been on this board for 15 years. We've met, I think, 4 times.
Yeah, yeah, yeah.
You know,
Is there anything that we're seeing?
We've only
Okay.
come to agreement on adjudicating one case.
Yeah.
Everything else has been carried on to be taken care of by the town council.
Yep.
Like I said, the town council does their job, we don't have.
We don't, that's right. Yeah.
You know, so as long as the town council's got their crap together, we're good.
Well, that, town council always has that together, right?
Right, now I've directed staff to mandate that you guys meet twice a year,
Okay,
and that they will coordinate scheduling that, and that's just going into the process now.
good.
And if there's no case, what we would do is we'd go through mock procedures. so
Yeah,
that you guys
like
would
that.
be familiar
Yeah.
with what's going
Be
on,
familiar.
and you could actually discuss things and rehash, well, this was done at this jurisdiction, and here's what they came up with.
Yep.
These are the laws that they felt needed to apply to this, so that you guys get a
So it's really case
familiarity
study,
with stuff.
yeah.
Exactly.
What, so the one we did decide on is in review or appeal right now still?
No.
The one for the Bean property, is that still?
Yeah.
It's been closed up.
It's been
i-
closed.
is it- Okay.
As-
Is it ever appropriate for the board
Yeah, do we
to,
ever-
to kind of do the postmortem on that and debrief and be in conversation with you all about that, or is that not?
There's some legal information that I think needs to be kept private, so I don't know if there would be a true debriefing.
I can give an update or a debrief once it's completely.
Okay,
Completely
final.
closed, yeah.
We're at like the 95% mark.
because if our decision was overturned, there would be some benefit in learning
Why?
Well, I
why,
don't think it's.
You
well,
know?
I don't know that it was overturned.
Yeah,
I don't
I've
know.
heard-
Well, it's
We
not
worked
complete
for
yet.
3 years on, basically building a case, working on the case, and then it was gonna go to court, and we were able to keep it out of court and come to a mutual agreement.
Okay,
So we're
okay.
finalizing that
okay.
action, and they're doing their part, and then we should be.
So it never really got adjudicated at the court level, it's kind of settled or,
It had
yeah.
gone all the way to the court, and there was any kind of overturn.
Poor guy.
If it had never been overturned or anything like that, I would have reported that.
Okay.
Certain.
Yeah, and of course, that would be public record anyway, right?
Yes.
The decision will be public record,
Yes.
so, and the testimony around that, so.
Overlook.
Yeah,
Exactly.
yeah.
Yeah.
I know to look right over here. I know to look to Kim, who's gonna help me find it.
Where you gonna find that?
When would our next meeting be then to do the
Yeah.
chair?
That is up to you
Is it a
all.
Wednesday? Is this, obviously
That's
for
up to
John, it
you
doesn't
all,
work,
of
but
when you wanna
Wednesdays
meet.
are good for me, generally speaking, so,
You guys let me. Yeah, I'm pretty
Yeah.
flexible.
okay.
Wednesdays.
So we want to shoot for Wednesday in the
Maybe
next couple
before we have
months.
something to meet about.
Well, I think we have to meet to
You have to
appoint a chair, so that's the next item. We would want to do that before we met
Have
for a
full
case.
Body.
Or-
Right.
Yes, you do.
And then you could
Is that what we're
review
looking
the
at?
bylaws and
Exactly,
rules of order and
Correct.
adopt them.
Yep.
Take a vote for adoption.
Okay, so there's one that's absent.
yeah, so we got one person absent
Yeah,
tonight.
I'm not on board.
Yeah, you just,
here
you're
for
heckling, right? So-
Right,
Yeah,
so,
that's why I wanted to sit out there and be in the peanut gallery.
Yeah.
They said, get comfortable.
Yeah, comfortable.
You're a surrogate member.
I don't know if you said this already either, but we have architectural review board meetings every third Wednesday.
Okay, so we would avoid that.
Yeah.
Right, so you could be
Yeah,
like the
third
second
Wednesdays they are
Wednesday or the first Wednesday.
Kim, would it be possible for you to hunt that down like you hunt us down for this meeting?
I'll hunt you
Could
down.
you, and then we
I'll
could
give
just
you some-
mutually
I'll get you
agree,
some-
looking at our
some
calendars,
dates.
John will be back in
right,
town.
I'll get you some dates.
Yeah,
Yeah.
and then just make that our next meeting. And then do we have to announce the agenda beforehand so
I
that
will
we
post the
can
agenda and everything, and send it to you by
'Cause you
email
can't
and everything.
do business that you've not
Correct,
announced? Is that true?
correct.
That is correct.
Okay.
The meetings will be taped. She will
Like your- yeah.
announce the meeting a week ahead of time
Okay.
so that
Yeah.
it's public notice.
Everything we just heard, right?
Yeah, so FOIA is totally
Yeah.
complied with.
Yeah.
Yep, okay,
Okay,
okay.
Takes care of it all.
all right.
So all the stuff we don't have to worry about. Say it.
Right, if
we
you guys
really don't
did
have a whole
business
lot.
between
That's-
yourselves, I don't think you got a town email account. So, she will be the central point in which everything will be distributed, so a lot of the records will be on her back.
Yeah,
So you guys shouldn't really be responsible unless you do communicate between yourselves.
correct, yeah.
All right, so we'll just close up for this evening, and I'll send you out an email with some dates. We'll try and get this done within the next month, and
you.
go from there.
Thank you very much.
Thank you.
All right. Good to meet you.